Hello, friends. Welcome to my channel. Today, I will be talking to you about the Witness Protection Scheme. In the words of Jeremy Bentham, witnesses are eyes and ears of justice. This scheme is a step in the right direction in ensuring the confidence of witnesses in trusting the criminal justice system of the nation. The Witness Protection Scheme in 2018 is the first legal enactment set up by the Indian government. The need for such an act was due for a long time. The Supreme Court in the state of Gujarat versus Anirudh Singh held that it is the duty of every witness to help the state by giving evidence. The aim and objective of the scheme are to ensure that the investigation, prosecution, and trial of criminal offences is not prejudiced because witnesses are intimidated or frightened to give evidence without protection from violent or other criminal recrimination. What is the background of this scheme? The Supreme Court in the state of Gujarat versus Anirudh Singh held that it is the salutary duty of every witness who has the knowledge of the commission of the crime to assist the state in giving evidence. First ever law reference to witness protection in India came in 14th Law Commission report in 1958. After that, 154th, 178th and 198th Law Commission report also recommended putting in place a witness protection scheme. The Malimat Committee report also batted for a strong witness protection mechanism and said that the courts should be ready to step in if the witness is harassed during cross examination. Reasons for hostile witnesses. The court has noted the following reasons for witnesses turning hostile during the trial: threat or intimidation, inducement by various means, use of muscle and money power by the accused, use of stock witnesses, a few alleged witnesses who depose falsely in favor of the prosecution as and when called, protracted trials, hassles faced by the witnesses during investigation and trial, the non existence of any clear cut legislation to check hostility of witnesses. The Honorable Supreme Court has held that the right of witnesses to testify freely in courts is part of Article 21, that is, right to life. The court said that the scheme will be the law under Article 141 and 142 of the Constitution until the enactment of suitable parliamentary and or state legislations on the subject. The bench has also asked all states and union territories to set up vulnerable witness deposition complexes as required by the scheme by the end of 2019. These rooms will be equipped with facilities to prevent the accused and witnesses coming face to face. Witness Protection Scheme 2018 identifies three categories of witnesses as per threat perception. Category A: those cases where threat extends to life of witnesses or family members during the investigation, trial, or even thereafter. Category B: those cases where the threat extends to safety, reputation, or property of the witness or family members during the investigation or trial. Category C: cases where the threat is moderate and extends to harassment or intimidation of the witness or his family members, reputation, or property during the investigation, trial, or thereafter. There are certain terms which are important to learn about the scheme. What is a witness? Who is a witness? It means any person who possesses information and document about any offense. Then who is the competent authority? It means a standing committee in each district chaired by district and session judge with head of police in the district as member and head of prosecution in the district as member secretary. Then the term is Witness Protection Fund. The expenses for the program will be met from a Witness Protection Fund to be established by the states and union territories. The states will make annual budgetary allocation for the fund. The fund will also be free to accept donations from national and international philanthropic organizations and amounts contributed as part of corporate social responsibility. The said fund will be operated by the Department, Ministry of Home under the state and UT government. Then there's a term called Threat Analysis Report. The Witness Protection Scheme 2018 calls for preparation of a threat analysis report of the witness by the Commissioner or SSP when witness applies for protection. The TAR will categorize on the level of threat perception and will submit suggestions. The Witness Protection Order passed by the competent authority will be implemented by the Witness Protection Cell of the State (UT). It provides for protective measures like ensuring the witness and accused do not come face to face during the probe, protection of identity, change of identity, relocation of witnesses, witnesses to be apprised of the scheme, confidentiality and preservation of records, recovery of expenses, etc. Change of identity. In appropriate case where there is a request from the witness for the change of identity and based on the threat perception by the Commissioner of Police in Commissionerates, SSP in District Police, investigating the case, a decision can be taken for conferring a new identity to the witness by the competent authority. Conferring new identity includes new name, profession, parentage, and providing supporting documents acceptable by the government agency. Then is relocation of witness. Competent authority can do so depending on threat perception. The last is filing of application before the competent authority. It can be filed in prescribed format before the competent authority of the concerned district where the offence is committed through its member secretary along with its supporting documents. As and when an application is received by the competent authority in the prescribed form, it shall forthwith pass an order for calling the threat analysis report from the Commissioner of Police in Commissionerates, SSP in District Police, investigating the case. Depending upon the urgency in the matter, owing to imminent threat, the competent authority can pass orders for interim protection of the witness or his family members during the pendency of the application. The threat analysis report shall be prepared expeditiously by the Commissioner of Police in Commissionerates, SSP in District Police, investigating the case while maintaining full confidentiality, and it shall reach the court. In the report, the Commissioner of Police in Commissionerate, SSP, investigating the trial shall categorize the threat perception and shall also submit suggestive measures for providing adequate protection to the witness or his family as contained in Clause 7 of the scheme or any other measures found appropriate. While processing the application for witness protection, the competent authority shall also interact preferably in person and if not possible through electronic means with the witness and or his family members, employers or any other person deemed fit so as to ascertain the witness protection needs of the witness. All the hearings on witness protection application shall be held in camera by the competent authority while maintaining full confidentiality. An application shall be disposed of within 5 working days of receipt of threat perception report from the police authorities. The types of protection measures include ensuring that witness and accused do not come face to face during the investigation or trial, monitoring of mail and telephoning calls, arrangement with the telephone company to change the witness protection telephone number or assign him or her an unlisted telephone number, installation of security devices in the witness's home such as security doors, CCTV, alarms, fencing, etc., concealment of identity of the witness by referring to him/her with the changed name or alphabet, emergency contact persons for the witnesses, close protection, regular patrolling around the witness's house, temporary change of residence to a relative's house or a nearby town, escort to and from the court and provision of government vehicle or a state-funded conveyance for the date of hearing. Confidentiality and preservation of records. All stakeholders to maintain full confidentiality and to ensure that under no circumstances any record, document or information in relation to the proceeding under the scheme shall be shared with any person except with the trial appellate court and that too in written order. Recovery of expenses. In case of false complaint, the Home Department of the concerned government can initiate proceedings for recovery of expenditure incurred from the Witness Protection Fund. In case the witness or police authorities are aggrieved by the decision of the competent authority, a review application may be filed within 15 days of passing of the orders by the competent authority. And last, this is the application format. With this, we come to the end of this video. In our next video, we will talk about vulnerable witness deposition centers. Thank you, and please like, subscribe, and share.